Good afternoon, good morning still, I think it is, everyone. I'm Tony Good, and I'm chairing this session on country of origin information. Now, the full title of the panel is Country of Origin Information in Refugee Status Determination. It's an important topic, and it's one I've got a personal interest in myself, because my own role in the asylum process, my own engagement with it began with the provision of what is now called country of origin information, though at the time when I began working in the mid-1990s, the phrase had not come into current use, still less had it been capitalized and given an acronym. So things have moved on quite a lot since the mid-1990s. So I began as a so-called country expert, providing expert reports on Sri Lankan asylum cases, and became interested in the process of giving evidence and how that evidence was received. And that's how my research involvement in this topic came into being. So I'm particularly interested in what the speakers today have got to say. It's something that I'm engaged in personally, and I'm greatly looking forward to the three papers. The first paper we have is by Famke Vogelaar. It's entitled Country of Origin Information, the Essential Foundation for Fair Decision Making. Famke has a PhD from VU University, Amsterdam, and she's been working as a professional in the field of asylum and refugee law since about 2005. She's worked with the Dutch Council for Refugees in Amsterdam, with Flemish Refugee Action in Brussels, and she's done research for UNHCR, both in their Europe Benelux office and in their Southern Africa office. Her PhD, which she defended in 2020, was entitled Country of Origin Information, the Essential Foundation for Fair and Credible Guidance for Decision-Making on International Protection Needs. As I said, it was at VU University in Amsterdam. Several chapters of her thesis have already been published in peer-reviewed journals, and her presentation today is based on the final chapter of her thesis, which includes her recommendations regarding the evidentiary assessment of COI. So, Famke, if you'd like to present.
Yes. Good afternoon, because it's afternoon here already. I'll share my screen. Is it visible?
Yes, it is.
Okay. So yes, this is to give a little bit of background information on my presentation today. For my PhD research, I looked at 4 key institutions in Europe that are involved with refugee status determination, and I looked at quality standards that they have set for country of origin information and how they applied these quality standards in practice. So my presentation is on, I think, what these conclusions mean for the cooperation on COI within the context of the European Union. Let me see my... okay. And I'm going to go into the reasons why I think that the need for all EU member states to apply COI in the same way and using the same sources can currently not be met due to the chosen framework for cooperation on COI within the common European asylum system. I will first discuss the evolution of EU practical cooperation on COI, and I will go into the provisions in the current legal framework for harmonization of the application of COI. And finally, I will discuss the shortcomings of this framework and my suggestions for a more solid basis for achieving a more systematic and uniform approach to COI in all EU member states. So, in the 1990s, you had overwhelmed asylum systems in Western European states, and this led to a more systematic approach to COI, or in other words, it led to professionalization of COI. Instead of refugee status determination officers keeping ad hoc COI collections, COI was now researched by people trained to do so in dedicated COI units. The change in character of COI led to calls for cooperation. First, these were informal exchanges of COI that go back to the late 1980s, but a step towards a more formal exchange came with the establishment of the Center for Information, Discussion and Exchange on Asylum, or CIREA, in 1992. CIREA was tasked with collection of country of origin information and joint reports based on guidelines that were set by the Council. The reports were confidential, which made it very hard for the information to be challenged in individual cases. Then in 2002, CIREA was renamed Eurasil, and under Eurasil, the main focus at first was still on exchange of COI, but the focus changed when the Common European Asylum System was formally created. Eurasil became the framework for the facilitation of practical cooperation around jointly compiling, assessing, and applying country of origin information. Eurasil worked towards ensuring access to the same information sources that have been collected and assessed in compliance with common standards and principles. So one of the first key objectives of Eurasil was to establish those common standards and principles. And they were laid down in the 2008 Common EU Guidelines for Processing COI. Then in 2010, Eurasil was replaced by the European Asylum Support Office. EASO was established to further enhance practical cooperation between EU member states, and a common approach to COI has always been an important aspect of EASO's activities. EASO has reiterated the common principles and standards that were laid down in the 2008 guidelines into a EASO COI report methodology, which is basically the same common principles and standards, just with a more detailed interpretation. On the basis of this COI report methodology, EASO writes COI reports, and these reports aim to further enhance access to the same COI. Nowadays, EASO also writes guidance notes and common analysis, which include an interpretation of EASO COI reports within the legal criteria set by the Qualification Directive. These guidance notes are not yet binding instructions for EU member states, but they might become binding instructions when EASO is replaced by the European Asylum Agency, which will have a much stronger mandate. Then, apart from harmonization through practical cooperation, EU legislation does include some minimum requirements for the use of COI. So Article 4.3a of the Recast Qualification Directive determines that an application for international protection is to be carried out on an individual basis and includes taking into account all relevant facts as they relate to the country of origin at the time of taking a decision on the application, including laws and regulation of the country of origin and the manner in which they are applied. So facts as they relate to the country of origin, your evidence is country of origin information, and this information needs to be relevant. Article 10.3b of the Recast Asylum Procedures Directive stipulates that member states shall ensure that decisions by the determining authority are taken after an appropriate examination. To that end, member states shall ensure that precise and up-to-date information is obtained from various sources as to the general situation prevailing in the countries of origin of applicants and where necessary in countries to which they have transited. And such information is made available to the personnel responsible for examining applications and taking decisions. Now, EU member states are not using the same COI and are not applying COI in the same manner. I take as example a research that I've done into the application of country of origin information and the designation of safe countries of origin in the UK and the Netherlands. And in particular, I looked at what COI quality standards were set and how they were applied in practice. For this research, I determined that the EASO COI report methodology was the most appropriate standard to apply to the practices of the UK and the Netherlands, because the UK itself stated that it applied the COI report methodology. And with regard to the Netherlands, it follows from the EU Asylum Procedures Directive that member states should apply the EASO COI report methodology when they're designating a country safe. My research showed that authorities in both countries relied on very different sources of country of origin information. And although the UK relied on a greater number of sources than the Dutch authorities, the quality standards were not applied properly or consistently. With regard to the Dutch policies on safe countries of origin, Albania and Kosovo, there was very few, they relied on very few sources. It were mostly secondary sources. The information was not always relevant, was not always up to date. And remarkably missing from the assessment were EASO COI reports, which the Dutch Immigration Service actually co-wrote and reviewed when it came to Albania and Kosovo. So in short, the Dutch authorities also did not apply the quality standards to the country of origin information in their designating Albania and Kosovo safe. From the perspective of the common European asylum system, I believe there's two reasons why it's still possible for decision makers, judges, and policymakers to use different COI and or apply it in a different manner. There is a strong focus on COI research rather than on the use of COI by decision maker, judges, and policymakers. And I think the focus has been on practical cooperation rather than through binding legislation, leaving much to the discretion of EU member states. So with regard to COI, I think it's very important to distinguish between two groups of users of COI, namely the COI researchers, and on the other hand, your decision makers, your judges, and your policymakers. Both groups approach COI in a different manner. COI researchers collect information and present the information in COI products, such as COI reports or in their responses with regards to individual queries. COI researchers aim to present information as objectively as possible. They aim to provide a neutral picture of the situation in a country of origin. Ideally, COI researchers are part of an independent COI unit that functions separately from the persons who are examining asylum applications, who are taking decisions, or who are making policy. Decision makers, judges, and policymakers, on the other hand, must analyze the information in the context of the individual circumstances of the asylum seeker and/or the legal criteria for international protection. They need to determine the meaning of the information for the existence of a well-founded fear or a real risk of serious harm. They need to assess the independence, the objectivity, and reliability of the information to determine the weight that can be attached to information, the probative value of COI. What is the information worth? The decision maker, judges, and policymakers, they need to balance and weigh all the available information to come to a sound decision on the protection needs of an individual applicant or of a group of people. And cooperation within the EU has focused on COI research and the quality of COI products. It has failed to recognize the importance of the evidentiary assessment by decision makers and policymakers and judges. And although the quality of COI products is very important, it is equally important for decision makers and judges and policymakers to be able to appreciate the quality of COI. They need to be able to appreciate the evidentiary value of COI and to determine what all the information taken together actually conveys about a well-founded fear or a serious risk. Now, when you look at the COI methodologies, they've been written with the purpose of producing COI. If you look at the 2008 guidelines, they state that the goal of the guidelines is to provide basic common criteria on how to process factual COI with the aim of facilitating EU-wide exchange on use of such information. The guidelines are to be understood by new as well as experienced COI researchers. Although the guidelines focus on improving the quality of COI products, it does recognize that it can serve as the basis for writing of other COI products, such as country assessments. When it comes to the EASO COI report methodology, it was purely developed for the purpose of producing and publishing different types of EASO COI reports. So the EASO methodology does not mention the use of principles and standards beyond the use in COI reporting. Then when you look at Article 10.3b of the recast Asylum Procedures Directive, it also has a focus on the research side of things. It includes the duty to obtain or collect precise and up-to-date information from various sources and to make that information available to the personnel responsible for examining applications and taking decisions. The emphasis is on the collection of the information by the member state. The Article 10 does not stipulate any principles or standards with regard to how the information should actually be assessed during the process of examining an application or taking a decision. So the 2008 Common EU Guidelines for Processing COI mentioned that the criteria, objectivity and impartiality, imply that whenever possible, the processing and production of COI should be kept independent from the decision-making process and policy-making process. According to UNHCR, this is a matter of credibility and authoritativeness of the COI provider. UNHCR states that the administrative independence from the decision-making authority are the most effective avenues to dispel perceptions of bias. Article 10 reflects the view on the need for independence of the collection process from the decision-making process. However, it fails to reflect the need for decision makers to assess the information for probative value in the context of the circumstances of the individual asylum seeker and the legal criteria for international protection. And then the focus on practical cooperation. There's no obligation on EU member states to apply either the Common EU Guidelines for Processing COI or the EASO COI report methodology. The Common EU Guidelines, in the Common EU Guidelines, member states are encouraged to apply the guidelines to COI cases. With regard to the EASO COI report methodology, the use of the methodology is only binding for EASO COI reports. While the EASO COI report methodology, first of all, intends to support the development of EU-level COI, EU countries are encouraged to apply this methodology to the national COI products. The Asylum Procedure Directive only refers to the methodology in the context of the concept of safe countries of origin, and only in a non-binding consideration 46, which state that member states should take into account the methodology while designating a country safe. So in practice, EU member states are free to apply any principles or standards they want, and they make use of this discretion. For example, Belgium and France refer to the Common EU Guidelines for Processing COI in their national COI products. The UK referred to the EASO COI report methodology in their operational guidance note and in their country policy and information reports until 2018. They now refer to the 2008 guidelines and the awkward training manual. The Dutch Ministry for Foreign Affairs states that they will follow in broad terms the common guidelines and the EASO methodology. But there are no legally binding commitments to the standards in national law in any of these mentioned member states or former member states, either with regard to COI products or the application of COI in the decision-making process. In Article 4 in the Qualification Directive and Article 10 of the recast Asylum Procedures Directive, that not only focuses on COI research, it also only refers to very few of the common principles and standards, as you can see from this next slide. So relevancy can be found in Article 4.3a of the recast Qualification Directive, which refers to relevant facts in a country of origin. The standards, accuracy, and currency can be found in Article 10, as it refers to precise and up-to-date information from various sources. However, explicit references to the most important standards are missing, such as a reference to the need to assess the reliability of information through an assessment of the authority and reputation of an author, the method of investigation, the consistency, etc. that reliability of the information will determine the probative value of information. A reference to the standard balance is missing. Through the use of different types of sources, a balanced or accurate picture of a situation and country of origin is made. The use of different types of sources aims to dispel as much as possible a bias in one source. But if you look at Article 10, it talks about various sources. It doesn't necessarily stipulate different types of sources. And information needs to be actively balanced on the basis of the probative value of information. It needs to be determined which information is the most reliable and is decisive for the assessment of a well-founded fear or a real risk. Finally, Article 10 neither refers to the need to use public information as much as possible, nor does it refer to the fact that the process of verification of information needs to be transparent. An applicant for international protection needs to be able to understand the meaning of the information for the risk assessment, to be able to assess whether new or other information has a chance of changing that risk assessment. And most remarkably, Article 10(3)(b) of the Recast Asylum Procedures Directive has not even been transposed by EU member states such as the Netherlands and Belgium. So the very few quality standards in EU legislation have not even been given any meaning in national legislation. So COI is considered the essential foundation for quality decision making. Yet the importance of COI is not always reflected in decisions or policy or even in EU cooperation. The inherent need of using the same COI and applying the COI in the same manner has not been met in the EU as a result of focusing solely on the research side of things and the choice for mostly non-committal practical cooperation. So to underscore the importance of COI and to enforce a more harmonized, systematic, transparent approach to COI, I would suggest that the standards are laid down in legally binding legislation. My suggestion is threefold. First of all the main principles and standards should be included in EU legislation. In particular, Article 33 of the proposed Asylum Procedure Regulation. There should be explicit references to relevancy, to accuracy, both with regard to the use of primary sources, but also with regard to the use of different types of sources, and not only various sources. Currency, reliability, balance, and most important, transparency. And second, the EASO COI report methodology, or the methodology that will be developed by the Asylum Agency, should be explicitly mentioned in the future Asylum Procedure Regulation. I think by explicitly including the main principles and standards in EU legislation, member states will be obligated to apply the standards as they have become independent norms. The wide discretion with regards to COI will be tightened. And by including the principles and standards in binding EU legislation that sees to the decision-making process specifically, will shift the focus from on the COI research side of things to the use of COI by decision makers. And hopefully, as a result, the evidentiary assessment of COI will get a more prominent place in decisions. I do believe that the methodology that will be developed by the EU Asylum Agency should reconsider the current EU COI report methodology to bring it more in line with the standards or the interpretation of the standards in the OCCAR training manual. The interpretation of the standards in the OCCAR training manual are much more detailed and in line with the principles of good administration, in particular when it comes to transparency and the duty to give reasons. Decision makers and policymakers need to show their thinking when it comes to the evidentiary assessment of COI. Without insight into the thought process, it will be impossible for lawyers to determine the exact meaning of the information for the most important conclusions, decisions, and policies, and to determine how new or different information could fit into the analysis. Thank you.
Well, thank you, Wimke. That's really interesting. And I mean, appropriately enough, the contrast you've drawn between the quality of the content and the evidentiary assessment is going to be taken up in the very next paper. So the issue that you've raised is actually going to get some more discussion. But I found that presentation really very interesting, and I'm sure if I get space at the end, I'll have various comments and questions to make. Okay, so let's move on to the next paper, which is entitled "It's Not What You Know, It's How You Use It" on the application of country of origin information to judicial refugee status determination decisions. And this is by Laura Scheinert and Valentin Fenneberg, who are going to present jointly, but I'll introduce them both at the beginning. Valentin Fenneberg is a PhD candidate at the Humboldt University in Berlin. He's a PhD student in the Integrative Research Institute, Law and Society. He studies political sciences, sociology, and philosophy. He studied in Munich, Berlin, and Oxford, and he's previously worked at the German Center for Integration and Migration Research in Berlin. His PhD research is in the field of socio-legal studies, and he's analyzing the application of country of origin information in asylum appeal adjudication in Germany. His co-author, Laura Scheinert, is a PhD candidate at the University of Exeter in advanced quantitative methods of social sciences and human geography, and she's a part of the ASYFAIR research network. Her PhD explores judicial training in the field of asylum and refugee law. She's a sociologist by training with degrees from the universities of Newcastle and Mannheim, and her previous work experience is in policy evaluation at the German Institute for Development Evaluation in Bonn. So I hand over now to Laura and Valentin for their presentation.
Thank you very much for the kind introduction, Tony, and I'll wait for Valentin to share the screen. There it is. Great. So hello again, and thanks so much for the kind introduction, Tony, and for a fascinating first paper, Femke. I really look forward to the discussion. And as Tony just said, we'll actually follow on, hopefully quite nicely, because we'd like to present a paper that's interested in looking at how COI is actually applied in legal reasoning. This presentation is based on a paper that's currently under review, and it's been written by Valentin, who's co-presenting, Nick Gill and Nicole Hollerer, who I'm sure you've met, and myself, Laura Scheinert. So what are we going to cover in the next 15 to 20 minutes or so? We'll first look at the puzzle. So what is it that motivates our research? What's the background to it? And I'll also give a brief overview of the literature that we've looked at. We then look at the cases that we've selected for analysis, and then present an overview of the methodology and some selected findings before we conclude with some remarks for discussion. So what's the empirical or maybe real life observation that's motivating our research? It is the observation that in Germany, between the years of 2016 and 2018, the higher administrative courts, which is the second instance judicial decision-making body in refugee questions, decided differently on the cases of Syrian draft evaders. Those federal states highlighted in blue awarded refugee protection. Those highlighted in yellow awarded subsidiary protection, and the green one hadn't made a decision at that time. Now, the Federal Court of Appeal in Germany, the highest administrative court in Germany, has not ruled on that question because they consider the question not important enough to require clarification from their point of view. But this difference in outcome is important for two reasons. The first is that asylum seekers in Germany are distributed to the federal states by a key, the so-called Königsteiner Schlüssel. And this key does not allow any or only very limited choice by the asylum seeker and subsequently appellants as to which federal state they can go to. The second reason is that the two statuses, albeit that subsidiary protection also offers protection against deportation and it guarantees basic rights, they do differ in terms of ease of access to residence and rights to family unification, with subsidiary status giving only restricted access to residence and restricted rights of family reunification. So for these reasons, this difference is actually quite startling, and it also has real life consequences for the appellants. Now, who are those appellants that we're looking at? We're looking at Syrian draft evaders. And why is that? That is because this group of people and this group of appeals really gives us as close as possible of a case where individual cases are as factually and legally comparable as possible, as far as we can get in the real world, because obviously we can't do an experiment and randomly assign people. So these cases are legally and factually comparable in that they are men of the military age between 18 and 42 years old who have either never served in the Syrian military or have served in the past and are now reservists, and to base all or part of their claim on draft evasion, that is, that they left Syria for the purpose of avoiding conscription. There are a few exceptions, which you can read in the small print on the slides. And now these appeals are so-called upgrade claim appeals, which means the appellant would have received subsidiary protection in a lower instance decision, either the BAMF or the first instance administrative court, but then applies or makes an upgrade claim for refugee protection for the reasons just outlined. It gives you better ease of access to residence and better family reunification rights. So the question really is, why is there this difference in outcomes at the federal level? And while I should really say that we cannot, and I really want to stress that we cannot explain why there are differences, and we do not seek to do so, we can look at how this divergence or how the decisions are justified differently by looking at the way in which COI is employed. And the focus on COI is relevant. I mean, you've just heard in Femke's excellent presentation just how important it is. It is one of the central aids to decision makers in RSD, and we aim to shed light on how COI is used rather than what COI is used. And we do this based on the assumption that consistency in the use of COI is desirable in light of the principle of treating like cases alike. And I guess Femke has given us some great insight into why that consistency, even in terms of collection and standards of assessing COI, might be somewhat lacking. But then our question really is, how is COI mobilized in asylum decisions to substantiate legal reasoning? And we will argue that it might be mobilized differently, and it might be less what you know, but how you use it. That's why we've got the little traffic sign at the bottom. So when we look at the literature, we can find, or we can make two main observations. The first one is that expert knowledge in RSD and refugee status determination is often discussed as a juxtaposition of anthropological analysis of knowledge and judicial perceptions of evidence. Again, Femke highlighted how there is a distinction between COI researchers who aim to present the knowledge objectively and decision makers who aim to apply and interpret it. And Murray talks of that as the different epistemic frameworks that are at work. So differences in how knowledge is viewed and different ways that we can know about the world and the world that the appellants come from. COI in courts is also used as cultural evidence or as informing hearing management. And the juxtaposition is really in those who kind of present the knowledge and the aims and purposes with which they do that, and those who apply the knowledge and their focus that they put on that. The second strand of literature focuses on the institutional and political dynamics of COI production and application. So it asks questions like, how is COI produced and how does it shape its application? It looks at, is the application substantially and procedurally correct? That strand of literature also offers a critique of the increasing evidentiary burden placed on appellants, or the ever-expanding role of expertise and expert knowledge that leads to almost a standardization of knowledge in refugee status determination. With this paper, we shift the focus ever so slightly, because rather than looking at the substantive application of COI or the procedural negotiation, we look at how COI is integrated into written decisions, and we do that by adopting a discursive lens. So what are the cases that we selected for our study? We selected a total of 13 higher administrative court decisions in Germany, 6 of them awarding refugee protection, 7 of them awarding subsidiary protection. And this is every first decision of each of the higher administrative courts in the different federal states in Germany. And all of these decisions were taken between December 2016 and June 2018. And as you can see, this was the time frame when the divergence in outcomes or decision outcomes was greatest, which is why we chose that time frame and those decisions. And I'll now hand over to Valentin, who will take you through our methodological approach and present selected results.
Thanks a lot. So what we did is we made both use of qualitative and quantitative methods, and I will only focus on the former now because it was the larger part of the paper. But just in a nutshell, the quantitative part showed us that there is no statistically significant difference in the number of citation instances between the rejecting and the affirmative decisions. For the qualitative part, we borrowed from critical discourse analysis, CDA, the sort of Norman Fairclough version of this methodology, which considers texts always in context. And the main features are intertextuality and recontextualization. That is how texts, in our case, COI in judicial decisions, are treated and framed in other texts. Another main feature is the thought that what is said in a text always rests on unsaid assumptions. So this is also part of our analysis, and we approach this in 2 steps. First, we look in a sort of close reading of the decisions, and we look on how the same evidence is interpreted differently based on different assumptions. And in a second step, we look at how COI, so actual COI reports, are represented and recontextualized based on these assumptions and how authority is attributed to different sources of COI. And I will give you some examples in a minute. Before presenting some results, I just want to quickly remind you why the difference in legal requirements of subsidiary and refugee protection is this important for our analysis. When it comes to refugee protection, refugee status determination is an assessment of whether a feared act of persecution is causally connected to one of the grounds of persecution. In our case, this would be the political opinion of a Syrian man having evaded military service. So refugee protection requires an ill treatment which is targeted directly at an individual attribute of the applicant. If this ill treatment is considered merely an inhuman action, it is or an inhuman action that happens disregarding as in an individual attribute, it is considered a serious harm and leads to subsidiary protection. And this difference is why German courts, or courts in general, which have to decide on this matter, have to consider and assess the state's motivation, the Syrian state's motivation, why the state persecutes its citizens. And this leads them to analyze or interpret the character of this state, which cannot be fully covered by COI. To clarify, 2 examples for this first step about the interpretation of the same facts. The first sort of fact or evidence is the interpretation of the Syrian state's precarity. It is overall accepted that between 2016 and 2018, there was a high pressure on the Syrian state, so to say, and that this state fought for its existence. So on the one hand, subsidiary protection decisions, those rejecting the refugee protection, argued that the Syrian government has to ensure its continued survival, mainly a military interest in returning draft evaders, because the state needs these men for combat and has no interest, objective interest, is one quote, to persecute them politically. I quote from one of these decisions: imprisonment in the case of withdrawal from military service is, from the Syrian state's point of view, a rather counterproductive punishment, because as long as it lasts, it prevents the person concerned from using his military strength. So on the other hand, refugee protection decisions, in contrast, considered the Syrian state as well as under pressure, but said this is the very reason why this state would treat every returning draft debater as an opponent, as a traitor. I quote again from another decision: in conjunction with the character of the Syrian regime that is aiming to achieve its goals without reserve by means that violate human rights, in particular torture, it can be assumed, so here we have the assumption as in the quote, it can be assumed that the Syrian regime has regularly ascribed a disloyal, politically oppositional attitude to people who have evaded military service by fleeing abroad of the war. Our second example is the also overall accepted fact that there were pretty high numbers of draft debaters leaving the country. But on the one hand, subsidiary protection decisions consider this high number as evidence that it cannot be a political motivation to each of these persons fleeing, because these persons mainly flee due to the fear of war. I quote, same decision as before: in view of the cross-cultural phenomenon of fear of war deployment as a motivation to evade military service in times of war, it is obvious to everyone that the flight and asylum requests by Syrian conscripts do not involve political opposition to the Syrian regime, but only have to do with the understandable fear of war deployment. On the other hand, refugee protection decisions also acknowledge the high numbers, but wouldn't interpret these high numbers in the same way. They say this alleged plausibility of the fear of war deployment ignores the fact that the motivations of conscripts in times of civil war are commonly not only based on the fear of war deployment, but are also decisively determined by the legitimacy of this military mission, and thus also by the legitimacy of the compulsory military service demanded from conscripts. So they sort of reject this depoliticization which comes with the subsidiary protection decisions. These are just two examples, and we try to look now at, in a second step, how evidence is represented based on these interpretations or assumptions. For example, we saw different evaluations of COI depending on the sort of decision. For example, subsidiary protection decisions criticized particular reports which did not support their interpretation of the Syrian state. Another example, maybe the most important example, is the different framing of information. And this is, I'm sorry, this is a very brief summary, but we can go back to this in the discussion. The different framing of information, for example, when key parts of the, or key evidence is only quoted in minor parts of the, or less important parts of the decision text, for example, on war crimes. And last example is a very selective representation of particular parts of reports, of COI reports, for example, when these parts did not support the assumptions made earlier. So this was a very brief overview of our findings. And as Laura said earlier, we're really keen on stressing that we don't want to explain how these decisions came into existence, but rather describe how facts and evidence is represented. But there are three possible interpretations which are sort of a step forward we can discuss together. One possible interpretation to our findings is that courts do assume a position and then approach evidence with the intention of interpreting and representing this evidence to support whatever position they hold, which would be a cause of concern. On the other hand, it's also likely, of course, that COI does inform and not only justify the decisions, but then we have a lack of transparency because we cannot examine or analyze how COI informs judicial decisions, because this is hidden from the written decisions. And the most likely interpretation is that there is, of course, a mutual influence between evidence and the assumptions made. That is, that COI does inform the position of the courts, but this position also informs the representation of COI. And this is basically what we want to show and what we want to analyze, and we look very much forward to discussing this with you later. Thank you.
Thank you very much. That was really interesting and brilliantly timed as well. Okay, so we can move on to the third and final paper now, which is entitled Source Assessment and the US Department of State's Annual Human Rights Reports. And this is written by Stephanie Huber, who is the director of the Asylum Research Centre Foundation, the ARC Foundation, which is a UK charity specializing in the production and use of country of origin information in refugee status determination. They review on a regular basis the COI produced by the UK Home Office and that produced by the European Asylum Support Office. And they also do case-specific research into COI on particular occasions, and they've been instructed in quite a number of UK country guidance cases. They're regularly commissioned by UNHCR to produce country reports on issues which have been identified as gaps in the availability of COI. As I said, Stephanie is the director of ARC, and she's a COI specialist with many years of experience of conducting COI research for use in the refugee status determination process, and also experience of undertaking COI reviews for various national and international bodies. I'm looking forward to what she has to say, and so the floor is yours, Stephanie.
Thank you so much for the kind introduction, Anthony. Let me just get my screen up. Here we go. Okay. So once again, thank you everyone for joining, and also for the conference organizers for having me on this panel. I'm grateful to be sitting here today with my fellow panelists and to bring my experience as a COI researcher to the discussion. So having heard from Femke, Laura and Valentine about the application of COI in judicial decisions, I thought I would start off by going back to basics and briefly explain the COI quality criteria, which should guide source selection and assessment. I will then share with you findings of a research project which analyzed one of the most widely referred to source in the refugee status determination procedure, which is the US Department of State's Annual Human Rights Report. So as you know, COI is an important element in the asylum process, as it helps to evaluate whether there's a well-founded risk of persecution or serious harm if the person would be returned to his or her country of origin. As Femke touched upon in her presentation, there are 5 main quality criteria or principles for researching COI, but also for presenting the research results. And these should ideally also apply to the assessment of COI by a decision maker. So these are relevance, reliability and balance, accuracy and currency, transparency and traceability, as well as neutrality. So with regards to relevance, the COI needs to be relevant to the individual circumstances of the applicant and to the issues raised by the case. So for example, to assess whether a lesbian may have a well-founded fear of persecution in her country of origin, information about the treatment of gay men may be limited in its relevance. And so on the other hand, information on the situation and treatment of women who do not conform to cisgendered stereotypes may be useful, as might be information on single women living on their own with no male partner. With regards to reliability and balance, the source should be reliable. So we know that every source has a political or at least ideological context, as well as a very specific mandate. And so reporting methodology and motivation should be assessed when selecting a source. Biases should be explained by, for example, including a kind of neutral source description. And to balance out any biases, a range of sources should be included. The COI should also be correct and valid at the time of researching. So different issues will require different degrees of timeliness. So for example, cultural and religious practices are less subject to change than information on the security or humanitarian situation. So a report that is several years old may still be accurate, while in other cases, like yesterday's newspaper article, may have been rendered out of date by more recent events. The information you collect needs to be traceable back to its source, so preferably a primary or original source, so that it can be independently verified and assessed by any user. And in practice, this means referencing all your sources and providing a direct and active hyperlink. COI research is also intended to be neutral and impartial. So it's not the role of COI researchers like myself to provide any opinions or analysis of the situation in the country of origin. This is in contrast to country experts like Anthony, for example. The aim of COI research is not necessarily to support an account, but to provide as much information as possible to allow lawyers, decision makers, and judges to make informed decisions. And neutrality also applies to consulting a well-balanced range of sources and using a neutral tone in language when presenting the information or describing a source. So in order to ensure that these quality criteria are met, we need to conduct a source assessment, which is kind of the process of thoroughly and critically evaluating a source against the quality criteria I've just gone through. So in practice, to evaluate a source, you should always ask yourself the following questions, like who provides the information, what is their mandate, what is their reputation, where does the funding come from, and what is their actual expertise on the topic. Then you would look at what information is provided and what shape does it come in. Is it a media article? Is it an eyewitness account? Is it a press release or a position paper, for example? And why is the source providing this information? Like, what is the motivation of the author? Is it, for example, to inform, to advocate, or is it just to fundraise for further grants? Also, how is the information generated? Like, what is their research methodology? Is the language and style of writing neutral or biased? And how is the information presented? Is it traceable? And is the source of information transparent? And lastly, you would look at when was the information gathered and when was it provided or published, because sometimes there's quite a discrepancy between that. However, it's really important to remember that a biased approach, so even a negative source assessment, doesn't mean that you need to disqualify a source. So information from a source with a certain bias can still be of value as long as you make efforts to mitigate. And this can be done by corroborating the information with that of other sources, by balancing sources, so by using a wide range of source types, if you can, government, NGO, international organizations, and so forth. And also complementing general information with kind of specific details. Which actually brings us now to the research project I'm involved in, looking, as I said, at the US Department of State's annual human rights reports. So I'm sure that most of you are probably familiar with this source or have at least had a look at it. And whilst it is intended to be relied upon to inform kind of American foreign policy and foreign aid decisions, it's also used as a tool for human rights defenders and governments to highlight human rights abuses and to hold regimes to account. And as some of you may know, it also carries a lot of weight in the refugee status determination processes throughout the world. And the reports are relied upon by COI researchers like myself, by asylum policymakers, UNHCR, for example, in their eligibility guidelines, the European Asylum Support Office, persons claiming asylum and their legal representatives. And they're also assessed by state refugee decision makers and immigration judges. So whilst the government source may have particular political imperatives, the user-friendliness of these reports mean that they're often kind of the go-to source for first instance decision makers and legal representatives alike. And what we've learned from embarking on this research project is that even well-established sources, they go through periods of change. And it's really important to continually assess the sources that you select or that you read, that you use, for your own COI research, but also as evidence submitted in court. So in spring 2018, the 2017 edition of the Country Reports on Human Rights Practices was published. And it was the first year covering events that occurred during President Trump's administration. And it became immediately clear that there were structural amendments to the 2017 reports compared to the 2016 edition, so the last year of President Obama's administration. So the 2017 reports had in general become shorter, and certain sections were removed or renamed, significantly altering the content of the reports. So we decided to conduct a really line-by-line analysis of 5 of the 2016 reports produced under the Obama administration compared to those published in the 4 subsequent years under the Trump administration, to highlight changes in respect to the structure of the report, like, for example, have sections been omitted, renamed, reordered, or new sections even being proposed? What about the language that's been used? Have there been any changes in terminology? What about improvements? Like, what improvements in human rights situations have been observed in these reports? And omissions. Have any human rights issues been omitted from one year to the other? We then investigated whether such changes were actually reflective of the reported situation on the ground as documented by other publicly available English language sources. And we focused on the top 5 nationalities of asylum seekers in the UK over the past few years. So these were Eritrea, Iran, Iraq, Pakistan, and Sudan. So our analysis basically revealed that the majority of observations relate to changes comparing the 2016 edition, so that produced under Obama, with the 2017 edition, so the first one produced under the Trump State Department. We also noticed that the majority of notable changes related to omissions. So this is really, really important, because unless you already know what you're looking for, you may never realize that certain information is missing from these reports. And there's also a risk that absence of information can be taken as indicating that the issue did not occur. And thirdly, most of these observed omissions were in relation to the treatment of women, the treatment of children and LGBTI persons, and those classified as the integrity of the person, so relating to arbitrary killings, disappearances, torture, arrest, and fair trial of individuals. And all of these omissions continue to be documented by other publicly available sources at the time of publication of each annual report. So I'm now going to show you a few examples of these notable omissions, reported improvements, and language changes we observed. So strikingly, the subsection on reproductive rights included in the 2016 report was replaced with coercion in population control in the 2017 and also in all the subsequent editions, dramatically changing the range of issues addressed in the respective reports. So whilst the 2016 reports had included information on access to reproductive rights and statistics on contraception use, maternal mortality rates, as well as the reasons for such high rates, this was all removed from subsequent reports, most of which were reduced, like you can see here in the 2019, to mention the absence of coerced abortion or involuntary sterilization. Actually, in the 2020 reports, which were drafted by the Trump administration, but published by the Biden administration, so just now in March this year, an addendum will be issued later this year to reinsert the information previously found in relation to reproductive rights. And the US Department of State has also informed that future editions will from now on re-include such a section and information again, which is great news. So other notable omissions with regards to women included, just to name a few that you can see on the slide, like with regards to Eritrea, the incidence of domestic violence, the lack of reporting of domestic violence, and the information that domestic violence cases were rarely brought to trial, and the reasons for a lack of state intervention. With regards to Iran, omissions related to legal restrictions on women's economic, social, political, academic, and cultural rights. With regards to Iraq, there was an underreporting of sexual and gender-based violence due to social stigma, societal retribution, cultural norms. Example in Pakistan was there was an omission on the actual situation of divorced women. And as I said before, we also observed omissions of information relating to human rights issues experienced by children, LGBTI persons, and persons living with a disability. So with regards to children, for example, we noticed that in the Pakistan report, they no longer refer to girls' low school attendance rates and the most significant barrier to girls' education being lack of access and cultural beliefs. The extent of child marriage in Sudan was also no longer referred to, as was, for example, the violence and fear experienced by LGBTI organizations and activists in Iraq, and the societal discrimination affecting LGBTI persons in Iran. And then also we noted that there was a societal discrimination faced by persons with disabilities in Iraq, which again was omitted from most reports. And omissions we found were also in relation to how the integrity of the person was kind of dealt with, despite again other sources continuing to document their existence. For example, these included, with regards to Eritrea, the mass arrests of persons suspected of evading national service, the corruption within the police force in Iran, or the occurrence of torture in prisons operated in the Kurdistan region of Iraq. So now that we've looked at omissions, I just briefly want to focus on reported improvements in the human rights situation that were observed to be inconsistent with other sources available in the public domain at the time of drafting the US Department of State reports that we came across. So in this particular instance, the 2019 Eritrea report stated, contrary to prior years, there were no reports that the government or its agents committed arbitrary or unlawful killings. And this was, although we found sources continuing to document that arbitrary and extrajudicial killings occurred in 2019. In the 2020 report, interestingly, they do mention arbitrary and unlawful killings, but only in relation to the region of Tigray in Ethiopia. And again, we found COI documenting that arbitrary and extrajudicial killings in Eritrea were much more widely than just in Tigray throughout 2020. With regards to Sudan, we noticed that two kinds of improvements were noted given the political changes Sudan went through in April 2019. So the 2019 report suggested that many abuses only occurred in the Bashir area, despite other sources continuing to document these occurring after the former President Bashir's ouster in April of that year. And also the 2019 Sudan report also alleged that a number of improvements occurred under the civilian-led transitional government once it took over in September 2019, such as, for example, releasing all political prisoners or the seizing of arbitrary arrests or detentions, just to name a few. And I'm sure, as you know yourself, by reading just the newspaper, these observations continued actually in the 2020 report, but actually more importantly, they continue to be not consistent with the situation as reported by other publicly available sources. So as part of our review, we also looked at in how far the use of language was amended. And what we observed was that there were many subtle changes in language that could be read to imply an improvement in the human rights situation. And this included the introduction of distancing language, source attributions, and softening the language used in previous statements. So just to show you what I mean exactly, with regards to distancing language, for example. In bold here, I've highlighted examples where distancing language was introduced. So, for example, whilst detention conditions were described as harsh in 2016 in the Eritrea report, in the subsequent years, they were documented as reportedly remaining harsh. With regards to source attributions, we've again observed those shown in bold at the bottom of your slide. For example, NGOs reported that rape was severely underreported crime, whilst before they would have just said rape was a severely underreported crime. As I've mentioned before, we've also observed a kind of softening of language, as we call it, possibly implying an improvement. So in this instance, the 2016 Iraq report referred to torture as being one of the reasons why conditions in prisons and detention facilities were described as harsh and life-threatening. And this was subsequently changed to physical abuse, although torture was still documented elsewhere in the report. And lastly, we observed in the reports produced under the current administration, well, I should say under the previous administration, that on occasion fewer general patterns were described, assessments were removed, fewer statistical data was included, less kind of illustrative incidents were detailed, and less specificity was provided on particular issues. Again, this is an example from Iraq. So whilst the 2016, 17 and 18 reports described the general pattern that detainees were tortured to death and included a Human Rights Watch report as an example, the subsequent 2 years, so 2019 and 2020 editions, only included 2 cases as reported, again, also by Human Rights Watch, where torture led to death in custody. Elsewhere in the 2019 report, it also used a local press article to report on the death of 9 detainees in custody during an interrogation, suggesting that they did not die of natural causes. So they did include examples, but by reducing a general pattern to 2 examples or 3 examples, it might be read to imply that the practice no longer occurs on a regular basis. And if you're a user of these reports and you just briefly glance over them, you might miss the actual general pattern here, that torture leads to death in custody. So having reviewed the main body of these reports, we also then analyzed in how far the executive summary sections of the respective reports were covered. So these are always found at the start of each US Department of State report. And I'm sure many users might only refer to that particular section. So we compared them across the years, but also compared what was omitted within the body of the report. And we basically made 3 observations. The first one being that all the country chapters had multiple tiers of abuses in 2016. So here you can see the example for Iran, but only 1 list in the subsequent editions. Secondly, we also observed that many abuses were omitted from the respective report's executive summary. So as I said, this is kind of important because some users might only refer to executive summary. So just to give you an example on Pakistan, 11 human rights issues were omitted comparing the 2017 to the 2016 executive summary edition, all of which then continued in 2018, 10 of which in 2019 and 9 in 2020, despite the fact that they continued to be highlighted in the respective sections of the country report, where you actually need to go and look for that information. In addition, there were 9 issues not covered in the 2020 report, which I've listed on the slide. And again, these are really important omissions. So for example, frequent mob violence and vigilante justice with limited accountability, violence based on gender and gender identity, or so-called honor crimes was no longer listed as a human rights violation in the executive summary. And the last observation was that the majority of such omissions were found to be internally inconsistent with the respective sections of the US State Department report, further underscoring the importance of users of the reports not to rely exclusively on the executive summary. So for example, in the case of Eritrea, the human rights issue restrictions on freedom of speech and press was included in the 2016 and 17 editions. However, it was omitted from the 2018 edition. And this is despite in the main body of the report, it continued to document that the government severely restricted freedom of speech and press, as it had done so in the previous editions. And interestingly enough, in the 19 and 20 reports, this issue was reintroduced in a slightly amended form to the executive summary. So just to summarize what we found, and the key message we want you to take away is, so our comparative research highlights several changes, many of which are quite nuanced and could easily be overlooked. However, when taken together, these changes have the effect of suggesting improvements in the human rights situation, which are not consistent with the situation on the ground, as documented by other illustrative sources. And as we all know, persons claiming asylum are often those who have been marginalized in their own country. And by omitting human rights abuses, instead of shining a spotlight on the situation of marginalized groups, these reports can actually have the effect of perpetuating the invisibility of these groups in countries of asylum. And this may actually result in certain types of claims for refugee status being dismissed if the US State Department reports, for example, are relied upon in isolation. So we therefore believe that caution really needs to be exercised when using the US Department of State reports, and that this should always be corroborated by other available sources. So in case you haven't seen them already, on our website, you can find a summary report, which contains the overarching key findings and key observations per country. We have also produced 5 country chapters, which go into much greater detail And they also include a repository of country information for each observation. And in the autumn of this year, we'll update all of these to incorporate the final findings from our review of the 2020 reports, which is currently underway. So I hope that our analysis is useful for you and also for practitioners conducting RSD when assessing the weight to attach to this source, but also when thinking about the weight to attach to other sources which are heavily used. And I just really briefly want to draw your attention to a recent country guidance case in the UK. It's called KKRS, which looked at surplus activity and risk of return to Sri Lanka, mainly for someone supporting or being a member of the TGTE. And interestingly, the upper tribunal of the Immigration and Asylum Chambers also critically examined the methodology used to produce the UK Home Office fact-finding mission reports to Sri Lanka, and as well as the Australia's Department of Foreign Affairs and Trade country reports on Sri Lanka. Again, two reports that are constantly used in the RSD process. And again, this is really indicative of how even well-established sources are critically examined by bodies involved in the RSD process, and we actually encourage the judiciary to do so even more. And again, just to highlight that on our website, you can also find critiques of our own critiques of the Home Office fact-finding mission report, and also the Department of Trade of Australia, which was actually submitted to court and hopefully assisted in their judgment. Thank you very much.
Thank you. That was really interesting. It's always been a bit of a mystery why the State Department reports have been given such weight in the asylum process, given that they weren't actually written for that purpose. I remember many years ago, and unfortunately I never got the details of this, I met at a conference run by Richard Wilson in Sussex, a man who had actually been an author of State Department country reports, who was horrified to discover that they were being used in asylum cases because he had no idea that that was a purpose for which they were being put. Anyway, those were three great papers.